All right. No, I mean, it appears that it isn't because you're getting angry throwing somebody's keys.
No, but it's the reason though, because she was drunk though, so you know what I'm saying.
Oh,
I
okay,
could have just let her leave.
all right, let's be clear. You were not doing this to stop her from. Hello.
Okay. All right. Thanks a lot.
Morning, Judge.
Hello. Hi. I like your shirt.
Thank you.
All right. Where are we on discovery?
Yes.
These are three nightmare cases, Judge.
Oh. So
You
you're
have
here
the
asking
motions.
for the bond conditions to be modified?
That's correct. We did it once on January the 16th, changed it from no contact to supervised contact. And now you'll notice on page 2 in the center of it, I've got a response request from the CPS worker. They'd like to move forward with family reunification. The civil court has not issued a written order.
Just 1 second, let me.
I'm sorry,
Just a second.
that was filed back on the 13th. Each one is identical.
All right, so I need the order from the civil court. When
There is no order, Judge. The court is not, as of yesterday, they have not signed an order.
All right, so who is the children's attorney?
The ad litem is a Kathy Stout. I have emailed and called her and had no responses on the 7th of February.
All right.
I do have the CPS worker as well, and I quoted her on the second
Alright.
page, but
Does anybody have Kathy Stout's?
I've
cell
got her.
number?
I've got her phone number.
All right, so if you'll give that number to Ms. Ferguson, or if you can call Kathy Stout and see if she
She
can.
probably won't answer me. That's why.
Oh,
That's
no,
why I
no, no,
said
I
she
think she
doesn't
would.
answer.
You know what, once you put it in the universe, then it's not gonna happen. See if
I'll get her.
she's available to zoom in.
All right.
All right, just have a seat.
Thank you, Judge.
All right, who's here on Channing McFarland? Court is calling 2025 CR 0000513, State versus Channing McFarland. Can I have parties announced for the record for the state? Defense?
Good morning, Judge. Dirk Ashball for Mr. McFarland. We're ready.
And are you Mr. McFarland?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Are there any applications?
No.
Mr. McFarland, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Court will find that the state is in compliance with discovery. Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented? Mr. McFarland, did you review the document entitled admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of unauthorized use of a vehicle? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility
Yes,
and up
ma'am.
to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. McFarland, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 100 days in the Bear County Jail under 1244, and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Yes. No objection, Judge.
All right, state, you may be excused.
Thank
Did you review the waiver and consent to stipulation of testimony and stipulations?
Yes, ma'am.
with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Just ask that you follow the agreement, Judge.
All right, anything you wish to say?
No, ma'am, I learned my lesson.
No, did you really?
Yes,
Because how
ma'am.
old are you?
Almost 40.
All right, you should have already known your lesson.
Yes, ma'am.
And where was she picking you up from? Where was she picking you up from?
From the house.
All right, somebody gives you, your girlfriend, now ex-girlfriend, gives you a ride, and you end up throwing her car keys, and then the next thing you know, she can't find her car keys because you threw them in a grassy area. And then she waits for you and you're driving off in her vehicle. You know, people would say that's just very trifling, you know?
Yes, ma'am.
So don't do that anymore. Court is going to find you guilty, sentence you to 100 days in the Bear County Jail under 1244, give you credit for any time served. There's to be no contact with Alexis Wood or Cassie, Cassie, Kynes, Kines. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, let's go off the record. Here's the thing. You don't seem to be ready for a relationship. All right. No, I mean, it appears that it isn't, because you're getting angry throwing somebody's keys.
No, but it's a reason though, because she was drunk though, so you know what I'm saying?
Oh,
I
okay,
could have just let her leave.
all right, let's be clear. You were not doing this to stop her from driving because she's intoxicated, because you had no problem with her picking you up and taking you somewhere intoxicated. So let's not play those games. So you're not ready for a relationship.
Yes, ma'am.
In order to get yourself ready for a relationship, get an orchid. Get one where the blooms are on it, because it's beautiful. Search through the store, pick the perfect orchid, take it home. And when you take it home, read up on it, discover how to take care of it. Once those blooms fall off and it's not looking the way it looked when you got it from the store, make sure you're able to get it to bloom again. If you're not able to get that plant to bloom again, you're not ready for a relationship. And the reason why I say that is because orchids take a lot of patience. No matter when you follow the instructions, it say do 3 ice cubes. I learned you're not supposed to put ice cubes on it. It say don't put it in direct sunlight, but sometimes no matter what you do, it's not going to bloom again. So until you can get it to bloom again, don't get in a relationship.
So orchid is a flower.
Yes, it's a flower.
Yes, ma'am.
And I'm serious about that, because the orchids will teach you a lot of patience. Don't cheat and go back to the store and get another one and pretend it's the same one.
Yes, ma'am.
All right, good luck to you, okay?
Yes, ma'am.
Thank you, Judge.
You're welcome. Are y'all ready on Arturo Villanueva? Counsel, you said you filed a motion for continuance?
Yes, I did, Your Honor.
Do you have a copy of that? Do y'all have his motion for continuance? And have you conferred with the state?
Yes, I did, Your Honor.
State, are you gonna have any objections to his motion for continuance? When are you asking for this to be recalled?
30 days, Your Honor.
Is what's happening with him going to take 30 days?
Possibly, unclear.
And Norma, what page is he on? All right, Cobb. All right. Hi. Hello, Attorney Soud. How are you doing?
Good. How are you, Your Honor?
All right. So defense counsel is here on Jada Cobb. So in this court, she's charged with abandonment, and defense is informing the court that there's an agreement or an order that hasn't been entered yet on the CPS side, allowing her for supervised contact. Is that correct?
Yes.
All right. And do you have any objections to this court ordering her to have supervised contact with the complainants?
And just a moment, Your Honor. Current order is supervised contact. What we're asking here is unsupervised contact It's our understanding that the civil court has agreed to that, but is waiting on this court to enter the full order. She
No,
is forwarding towards family renewal. And it's my understanding that Ms. Cole, that there is a trial set for April the 19th. Reunification is expected before that. Is that correct?
Yes.
no, she's not under oath.
Sorry.
So this is the court's
Let me ask
question.
that to Ms. Stout.
Well, no, we're not on the record yet. Here's my question.
We're asking for unsupervised.
No, but I want to know what's on the CPS side, what has the order that hasn't been signed yet by the court? What has been agreed to? Is it unsupervised or supervised?
Unsupervised pending the order from the criminal court.
All right, now we can go on the record. Court is calling NIMAG number 764-331 and 764-332 and 764-333. State of Texas versus Jada Cobb. Could I have parties announced for the record for the state?
Ashley Jones.
Defense.
Bud Rittenhour.
All right, state, the defense has filed 3 motions asking for a modification of the court's orders here. And they're requesting that the defendant be allowed unsupervised contact with I'm assuming the complainants in this case. Do you have any objections to the defense's motion?
We do not, Your Honor. This case did happen well, or almost a year ago. She has been with CPS since that time, has been testing negative, including all of her classes. Based on the email from the CPS attorney and based on the guardian ad litem's recommendation, there would be an agreement.
All right, and to the guardian ad litem, do you have any objections to this court ordering unsupervised contact?
No, Your Honor.
All right, and when's the last time she was tested? Does anyone know? When was the last time you were tested?
Like 3 days ago, I had a hair follicle and a P test. I do a regular every month.
Okay. All right, then, based upon the guardian ad litem's recommendation, the court will then allow for unsupervised contact. Is there anything else?
Not from the state, Your Honor.
Nothing from the defense, Your Honor.
All right, we can go off the record. And where are you expecting this case, the criminal case? What are you all expecting?
Your Honor, the case is not indicted yet, so at this point, I have not reviewed it for an offer, but I can be in contact.
All right, if y'all would make sure that that's done, because I would hate for the case to be indicted and then she's taken in custody and she has children with her. So at least if you all could give him notification if an indictment is coming. And then counsel, if that's going to happen, you can come to the court for a bond.
All right, Judge.
Your Honor, just so the court is aware, I do believe this is an arrest case initially.
Oh, was it?
Yes.
Oh,
so
okay.
the
All right then.
indictment, she's not going to get re-arrested with the case.
All right.
Hoping
Thank
there
you.
wasn't a change. in
Because
public.
I was like,
Some
because
counties
that's
do
the
that.
last thing anybody wants.
Yes. Your Honor.
All right, so Ms. Cobb, what I can tell you is if there are any issues, you can always come back to this court. Counsel, if there's some update or issues on the civil side, just let the court know.
All right, Judge.
All right, and thank you so much, Attorney Stout, for zooming in.
Yes, thank you, Your Honor. Always a privilege.
All right, have a good day.
You too.
All right, counsel, if you want copies of this,
Do, Judge.
then if you'll take it to the back, they will give you copies, and then please bring them back to me so I can put it into the system.
All right.
Thank you.
Thank you, Judge.
You're welcome.
Thank you.
You're welcome. Alexander Rangel, Christopher Beltran. Christopher Daniel Beltran. Who's the attorney? Who's the attorney for Christopher Beltran?
Hernandez, he's not here, Judge. We'll move him next, back along.
Christopher Cameron.
Present.
All right, counsel, on this case, where are we?
We have conferred, we have an offer that we have not accepted.
Okay,
It's our third setting, so we're still kind of,
all right, so I'm gonna give you all a plea deadline date.
yes, Judge.
That's an alias of mine. That's not my real name, Christopher Cameron. It's Matthew Brown.
All right, I'll make sure this is on here.
Okay.
How old are you, sir?
43 years old now.
All right, Ms. Ferguson, set this in 3 weeks. What date are you available, counsel?
Is the step after the plea deadline, the discovery deadline?
No,
Is it,
after the plea deadline day and it's jury trial day. The week of March 17th. Is that good, Norma?
yes, Judge, that's good. That's fine. We'll be ready.
All right, your plea deadline date is going to be on March 18th. At that time, you need to let the court know whether you reached an agreement. If you have not reached agreement, after that, it will be a jury trial date.
March 18th. Got it.
Yes.
Thank you, Judge.
Great, thank you. And Norma, what page is he on? Thank you. Juan Caballeros. I know I pronounced that. I put a B in there. Yes. All right, come forward. Is this still going to be a contested hearing?
No, Your Honor. After visiting with the prosecutors, about 3 different ones this morning, we have an agreement. It includes taking responsibility for a number 1 that's in a different court. That setting is on April 1st.
Okay.
Prosecutors think we can get it done in the next 2 weeks. We can. It involves a JSAT down there. That's followed by a plea or true to that same offense up here for a withdraw and continue alternate amendment.
All right, so you all will need to tell me why I should do this, and we can get into that once you all plead on the motion to revoke. All right. So Ms. Ferguson, on this case, and counsel, what court is the other case out of?
County Court 13.
Are you able to get that any sooner?
Well, oh no, well, we're gonna, it's set March, April 1st, but we're gonna try to get it, squeeze it in the next 2 weeks.
All
We'll
right.
try to move it up a couple of weeks.
So what we'll do then, Norma, can you set this for March 20th? And then counsel, if it's sooner than that, just let us know.
Right.
Is that a good date, Ms. Ferguson? All right, you have an active warrant. Your attorney will need to take care of that.
Your cell phone with you? Is there family members here?
DeAndre Coleman. Doug, I knew if you were here, you would be able to get in touch with Stout.
I'm useful. Judge, we just got discovery sent to us on the 20th, so I've only had it for 7 days. I'm still looking. I think I'm probably gonna have to do some investigating. So
All right, is there any CPS records involved in this?
I don't believe so because he's not a parent of
Okay.
this child. That was his sibling.
All right, Ms. Ferguson, I need a 30-day reset on Colwyn for discovery. All right, April 1st will be your discovery date, and state you need to be prepared to tender an offer on that date. All right,
Just got
thank
it.
you.
Judge, what's that date again? I was looking
April
at the other.
1st.
Really?
And that's true. It's not April Fools. All right, do you need anything, sir? Any questions? All right, thank you. Jamarian Greer.
Morning, Judge.
All right, so as stated before, you were in jury trial.
I was in jury trial, Judge. Apparently the state has some surveillance videos or something, and there's multiple defendants here. So I need to look at those. I haven't had the opportunity to do that.
All right, Norm, if I can have a 30-day reset on Greer. All right, so we'll be back on April 1st.
Could I be April 3rd? The same day I'm coming back on Mr. Cervantes?
Yes. All right, we'll bring you back on April 3rd. Once you sign the reset form, you are excused. Yes. All right, just have a seat. Your attorney will bring that to you. And thank you for dressing appropriately for court.
I had a question.
Yes,
For us, work.
yes.
Possible. Where that could work.
All right. Have you talked to counsel, if you confer with the state on whether or not he can work? Are you currently employed?
No.
All right, so that's something your attorney will need to approach the court with.
Yes.
If you can confer with the state and see if they have any issues.
Okay, Judge, I'll check for the same.
Court is calling 2024 CR 012861 State versus John Cowan Berry. Could I have parties announced for the record for the state? Defense,
Renee Munoz.
and are you Mr. Berry?
Yes, ma'am.
And counsel, are there applications in this case?
Yes, Your Honor, there are applications.
All right. Ms. Abrams, there's an application. Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor, that's correct.
Court will find that the state is in compliance with discovery. Mr. Berry, did you review the document entitled Application of Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
No, Your Honor, on the dating count two, the prior conviction date should read 22nd of November 2022 rather than 22nd of January. State moves to amend the information. State waives the repeat offender enhancement allegation.
And Defense has no objections to those changes being made, Your Honor.
All right, do you understand the state is asking that a substantive change be made to the indictment?
Yes, ma'am.
Do you understand that your attorney has 10 days to prepare for trial?
Yes, ma'am, Your Honor.
And are you waiving those rights and do you wish to proceed?
Yes, ma'am.
Perfect. Then the state is proceeding only on count 2. Did you review the documents entitled admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, Your Honor.
Did you understand you're charged with evading arrest detention with a previous conviction as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, ma'am, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am. Yes, ma'am, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am, Your
And
Honor.
did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
That is correct, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Berry, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am, Your Honor.
Anyone promised you anything other than the plea?
No, ma'am, Your
Are
Honor.
you satisfied with the way you've been represented?
Yes, ma'am, Your Honor.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am, Your Honor.
According to the plea, the state is proceeding on count 2. Punishment is to be assessed at 2 years in the state jail facility. The state recommends community supervision. Did you understand that to be the plea?
Yes, ma'am, Your Honor.
Defense is at the plea.
That's correct, Judge.
State is at the plea.
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am, Your Honor.
Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 3 years. There be no contact with Target and Academy Sports and Outdoors, and a referral to felony drug court. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am, Your Honor.
Then to count 2, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence. Did you review the waiver? I'm sorry, any objections?
No objection, Judge.
Did you review the waivers with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, yes, ma'am. I understand, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
If we may, Your Honor.
All right, state, they say that there is a restitution amount in the police report. Well, let me take that back. Is there any restitution from the Target or Academy?
That is our understanding as well, Judge.
All right, anything else you wish to say on behalf of your client?
Your Honor, we respectfully requesting that the court follow this plea bargain agreement. My client was not without his struggles and faults. He has been battling some issues related to mental health as well as substance use. He is willing and able to make a change, in my opinion, and will work any programs that the court deems suitable as far as treatments or other conditions of community supervision. He did want me to ask the court if he could be allowed to make the appointments out of custody as he has a place to live. And he stated that he would definitely make all appointments as scheduled as far as a potential TAP or mental health evaluation. I notified him that would be up to the court. But aside from that, Your Honor, we're just requesting that this honorable court follow the plea bargain recommendation.
All right, do you have any children?
Yes, ma'am.
What are their ages?
I have one daughter. She's 14.
All right, and does she live with you or no?
Not right now.
When's the last time you had contact with her?
Just right before I was incarcerated.
And how often have you been using?
Just like once or twice a month.
All right, we're not here for once or twice a month of using. People don't pick up, these theft cases and running away from the police for
Correct.
once or twice a month. And in the police report, it said that you had drugs on you. So again, how much are you using?
Every day.
All right, so why are you being dishonest?
I was thinking about the visit. I'm sorry. I was.
All right, so what drugs have you been using every day before you were taken into custody?
Meth.
All right. And how far did you go in school?
I had my GD.
All right, this is what the court is going to do. Court is going to sentence you to 2 years in the state jail facility, suspended and probated for 4 years, and state your excuse. In custody, the following is to occur: a referral to felony drug court, TAP evaluation, MIC evaluation, follow TAP results. There's to be regular reporting by Zoom or in person, regular random UAs, 200 hours of community service restitution. I'm going to order the theft course. Once he completes that, 100 hours will be deducted. And then there's 100 hours if he decides to better himself through a trade school or counsel. If there's something else that he does to better himself, just bring it to the court and I'll consider that as community service hours.
Yes, Your Honor, will do. Thank you for that.
Otherwise, you're going to end up picking up trash off the side of the street.
I understand.
There's to be no contact with Target or Academy Sports and Outdoors. There's going to be field visits 1 time per month for 8 months. Probation, is there anything else? I'm sorry. Oh, thank you. There's to be proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. Anything else, probation? Is there anything else you need from the court in order to be successful?
No, ma'am, Your Honor.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am, Your Honor.
And I'm sorry, probation, there's to be no unsupervised contact with minors. All right, we can go off the record. In this court, in order to be successful, communication is key. If there's an issue, let your probation officer know. If you feel like you're going to use, let your probation officer know, and
Yes.
we'll take it up. If for any reason you feel as though they're not addressing your issues, you can always come back to court. You understand?
Yes, ma'am, Your Honor.
All right, good luck to you.
Thank you, Your Honor.
Thank you. Beltran, Daniel Beltran. All right, if you'll come down, court is calling 2019 CR 9959 State versus Daniel Beltran. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Tony Hernandez, Your Honor, and I believe it's Christopher Daniel Beltran.
Oh, thank you.
Thank you, Judge.
And are you Christopher Daniel Beltran?
Yes, ma'am.
All right, Mr. Beltran, did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision, and also First Amended Motion to Enter Adjudication of Guilt and Revoke Community Supervision, and state's pending motion to supplement motion to enter adjudication of guilt and revoke community supervision? With your attorney, did you understand it?
Yes, ma'am.
And counsel, you'll need to do a trial court certification.
We did.
No, this is the old one.
Oh,
This is the
that's-
one I have.
They printed one out, Judge, and I gave you, that's the only one they. there's
Oh, no, we
form.
have some now.
Oh, they gave me one from the back earlier today.
Okay,
That's the one we signed.
I do not have it. All right. Are you the same Christopher Daniel Beltran who was placed on deferred adjudication in 2019 CR 9959 for the offense of burglary of a habitation on January 21st, 2020 for a period of 10 years? Is that you?
Yes, ma'am.
All right. State?
Yes, Your Honor. Violated condition number 41 on or about the 18th day of March 2023, Lake County, Texas. The defendant, Christopher Daniel Beltran, living there, failed to comply with.
Just like that. Oh, thank you.
My rock and roll, Your Honor, I'm calling.
All right. Thank you.
Then and there failed to comply with the rules and regulations of county drug court by failing to call the urinalysis line in violation.
How do you plead to that? True or not true?
True. We'll waive the remaining violated condition.
Any objections?
No, we don't.
Did you understand by pleading true to violation of condition 41, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
And you entered a plea to counts 1 and count 2. So that will be true, and that will relates to counts 1 and counts 2. Do you understand?
Yes, Your Honor.
All right. All right, the court will find violation of condition number 41 true. Is there a proposed agreement? All right, and defense, what are you requesting?
Your Honor, we're requesting the court continue him on his deferred adjudication.
Why should I do that?
Your Honor, it's in summary, and we have his father here today to testify for him. Christopher has been on deferred adjudication since 2020. During that 5-year period, he has spent most of that 5-year period either incarcerated or in a safety program. He's been to safety twice, Judge. He has over 311 or about 311 days in jail. During the interim, Judge, he's also so we're clear with the court, Judge. He's in April of 2023. He was arrested in Del Rio and charged with a federal case of transporting aliens he'd gotten involved in something with his uncle. He has sat out 21 months on that particular case, and he's been incarcerated that entire time. He's 27 years old now, Judge. He's had significant opportunity to assess his life, and he has told me, and his father has confirmed, that he is much different now than he was 21 months ago. What has happened is that he's realized the importance of his children in his life, the importance of being a role model for his children. He has done something that he hadn't done before, which is while he was incarcerated, has availed himself to parenting classes, to anger management classes, to a GED program, to a substance abuse program. He hasn't just been sitting around. In addition to that, Judge, while he was in federal custody, he was a trustee. While he's been in county, he's been a trustee. He appears from all conversations I've had with him and his father to have finally realized at 27 that this isn't the life that he wants for the rest of his life. He is subject to supervision under the federal case for another 3 years. He's on supervised at least for another 3 years. And if the court continues him on his community supervision here, he's got another 5 years on his probation. And then, of course, if he screws up at any time, the court can hit him with the maximum. He understands that. He's asking the court to take one final chance on him. His father here is here, and his father believes that yes, in fact, he has changed the conversations. According to his father, the conversations between the two of them have switched from, poor me, when he got picked up in the federal system, shortly after that to, well, what am I doing to my family? What is this impact having on my son? He's got a 14-year-old son, I believe. Yes, a 10 and 14-year-old children, and then 10 and 8. I'm sorry, 10 and 8. And they're asking for him. He has regular contact with them, but they're asking, when's he going to come home? When can I see my dad? And that has had a profound impact on him. He also has I think a 14-month-old daughter that he's never seen in person.
Right, so this is what I don't understand. People always, when the rubber meets the road, then all of a sudden they have this epiphany. So whenever people are placed on probation in this court, I don't do cookie cutter conditions. So I gave you all the help. I sent you to SafeP, and that was, you're going to SafeP. I know it was in custody, but that was to help you with your drug issues. Then I ended up sending you to felony drug court. So, and this is not your first motion to revoke. So you would have thought I would have got your attention on August 2022 on that motion to revoke. And that motion to revoke, what I did was I alternately amended your conditions to ISF and also felony drug court so they could get your life in together. And you know what you did when you came here on that date? You're like, I've changed. I realized, I had this epiphany. I realized that, I can't keep living my life like this. I'm going to get it together because I have children. I mean, the question for the court, I don't know who the mother of your children is or why she keeps saying, you know what, I'm going to give him another shot. Because you can't keep giving people different shots when children are involved, because children who are underage, they don't get to choose who their parents are. They don't get to choose, and say, you know what, dad keeps doing crazy stuff, going to jail, won't get his life in order. I'm not waiting around for him. And the mom just keeps hanging on as though the person is going to change. Maybe you have changed. Maybe this was the epiphany for you. I don't know. But at this court, this is the end of the road.
Judge,
So-
if I may, Judge,
Yes.
Christopher would like to address the court and he's talked to me about the previous chances he's had. And he wants the court to understand what the difference is and how he came to that.
All right, you can
position
raise your
in life.
right hand. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Christopher Beltran.
All right, do you have questions?
Yes, John. Chris, you had indicated earlier to me that you wanted to address the court. You understand today that she's going to make a decision on your motion, on the motion to enter adjudication of guilt and revoke of probation. Is that correct?
Yes.
What is it that you wanted the judge to know before making that decision?
I want to let you know that like my first few times messing up, I was mentally weak. But this time around, I spent a lot of time getting myself together, you know, like just doing things to better myself, you know, because I'm doing it for my kids, but I'm doing it for me too. You know, I understand I messed up plenty of times, but you know, I'm ready to be like productive in my life. This ain't my life I want to live. This ain't me.
Chris, tell her the things that you did while you were in federal custody.
I was going to reentry. I did AA. I did anger management. I did parenting. I also was holding a job. You know, just trying to stay positive, trying to stay out the way, and just get ready for when I come home.
Now, the previous times that you were either in jail waiting for a hearing or in jail waiting for the case, were you doing any of that kind of stuff?
No, no.
So what changed or what made you want to do it this time?
We're just tired of this. You know, it's time to grow up. I'm getting older, and I spend a lot of time incarcerated. So this ain't the life I want to live.
In fact, of the 5 years that you've been on deferred adjudication, about how many of those have you actually been on the street?
Like 8 months, 8-9 months.
The rest were spent either in jail or in some type of residential treatment facility, is that correct?
Yes,
Or in federal custody, is that correct?
yes.
you go out and decide to have a child with somebody when your life is not even together?
It wasn't just happening,
I mean, things don't just happen. I mean, you
I
were an
understand.
active participant, I'm assuming. Nobody was drugged. So when you didn't have employment, how were you feeding yourself?
I would work little side jobs here and there with the cell contractor I used to work with.
Right, and where were you staying? Who were you staying with?
I was staying at my father's house.
All right, so you had, even though drug court was putting number one on their list for you to maintain your sobriety, you did have a place to stay.
Yes,
All right. And then this is the third motion to revoke for you.
yes.
All right, I'm not going to continue down this path of giving you more and more chances. The court is finding violation of condition number 41 true. The court is going to grant the motion, find you guilty, revoke. And the court is finding you guilty of counts 1 and counts 2. Probation, what is the restitution amount?
Judge, the remaining balance or the restitution is $2,734.
And who is that to?
There are two victims, Anna Martinez and Stephanie Carrazzo.
Mhm.
I can check to see if we have separated.
All right, while she's checking on that, state, what are you requesting with regards to punishment?
State's requesting
do you know her? I
Oh.
was like, yes, I'll see her tomorrow.
All right. Tell him I said hello.
I will. I'll be very excited.
All right, so, where are we on discovery on this case?
So I worked with Mr. Edelman on this. There's a little more discovery or investigation I'd like to do on my own, so we are asking for a recent